Right, so let's resume our discussions with a presentation by Barbara Dew, who will talk about the legal terminology and the work on legal terminology done by the Court of Justice. I asked her to explain what a jurist linguist does within the DG Trad of the Court of Justice. I'm an administrator within the Projects and Terminological Coordination Unit of the Court of Justice. I'd like to present the different projects that we have within our translation department. Now, why legal translation? Well, in order to improve the understanding of the concepts of national law, to allow the jurist linguists to save time, to avoid repeating the work that has been done before, and in order to have a better terminological consistency in our texts. So how do we do that? We conduct terminological research, we create terminology fact sheets, we pre-process them, and we ensure quality treatment as well. Now, who does legal terminology? Who produces legal terminology? Well, the jurists and linguists of the 23 language units. Our unit projects and terminology coordination is there to ensure the quality of the content from a terminological point of view. And of course, the information sheets, terminology sheets are available to other departments. Indeed, our material is made available to all, and DG Trad has a database. It's a terminology database called Courier Term. We do produce punctual terminology, which means that any jurist linguist can create a sheet when they are coming across, let's say, a difficulty. Then we also produce specific thematic terminology, and we have a quality assurance project. How does it work? The jurist linguist of the language of procedure, which means the start language, will provide explanations on the national concept that may be difficult to construe or delineate in another language. This is contained in the fact sheet, which is then transmitted to all other jurist linguists responsible for the translation of the text concerned. We also produce thematic terminology. If we have, for instance, applications with very short or very tight translation deadlines, it can be very useful to use thematic terminology. So far we've collected the rules of procedures. It's called Judith, and we also have concepts in the framework of compared multilingual legal vocabulary project in family law and the law on foreigners and criminal law as well. We are at the moment developing a number of fiches in criminal law as well, and we're trying to do so in the framework of the project I will describe later on, the connected project. Jurist linguists also use the terminological analysis we have conducted. One pre-processing system allows the translators to look at the multilingual fiche that we have produced. Another type of pre-processing is based on the knowledge of the legal expert and translator of the unit of the language of procedure. This is very interesting because these fiches will present information in a very structured way, in a way that can be accessed to all and at any time, especially when the different documents are translated when it comes to, for instance, a preliminary ruling procedure, and when there are replies, rejoinders, and so on. And this is a way to ensure legal correspondence. This is an example of a terminological pre-processing based on the VJM collection. We have conducted the analysis of the ruling in C37614 following a request for preliminary ruling sent by Ireland. It contains terminology in family law. We suggest that the translator looks at the fiche proposed in the last column with hyperlinks. We indicate the French term in the first column as found in the judgment. In the second column we have the term as part of curia term, and the third column indicates the original language, English in this case. This third column also allows us not to lose any concepts in the framework of the procedure. In other words, we keep the terms of the original document up until the moment of the judgment. Because, of course, the documents to be translated can be in different languages. In that case, the Irish jurist linguist did give a number of precisions or clarifications of the term contact rights or rights of access, which is droit de visite. These two terms, contact rights and rights of access, were part of the preliminary question, and the question was, are these two terms covering the same concept? On this fiche, you see that rights of access is the terms used in Irish law. It is in the red box. In the general comment on the same fiche, an explanation was given by the Irish legal expert, saying that there is at the moment a recommendation to use contact rights rather than rights of access. It also indicates that the term contact rights is used by doctrine and case law as part or in the meaning of the Hague Convention. This is another rich example in the framework of the quality project. We have conducted a pre-treatment, or pre-processing ones, for strafbaar feit in Dutch, in the Dutch system, and Straftat for the German legal system. We always say which legal system is concerned, because there can be different languages and different legal systems. In both cases, the jurist linguists in the original language gave information to better delineate and understand the concept. The description of the concept core that could apply, and this is a human behavior that goes against the law, and that can lead to a sentence. In the German part, we can see that Straftat is used in case C214, and strafbare Handlung is the synonymous used for an equivalent to strafbaar feit in the case mentioned. This is the same part of the fiche in Dutch. In this part we can see that the Dutch term was used in C 8812, so it's strafbaar feit that was used, and the Dutch legal expert added delict on the fiche because it is also used in the Dutch legal system. In the general explanation, we see that another explanation by the lawyer-linguist was added to avoid confusing the Dutch delict and délit under French law, délit being a more restrictive concept. If we look at the French part of the same fiche, so we're still talking about similar concepts, but I preferred to have several slides in order to facilitate visualization of the concept. In this part, we see that the concept can be covered by two terms, infraction and infraction pénale. The added value of the work of the lawyer-linguist is this general statement that helps other lawyer-linguists understand the fact that infraction is a generic term for the most restrictive concept of infringement, contravention or crime, and there's also a connection with the fiche dedicated to each one of these different concepts. If we now have a look at the same fiche in English, we see that there are three synonyms offered, and the use of the different terms can vary according to legal systems. There are several legal systems in English. So based on the French explanation, we see that there's a false correspondence with the French term crime, indeed, or crime. Crime, indeed, does designate the principle of the infringement, whereas crime is one type of criminal offense in the French system. Thank you for your attention.
Merci Barbara. On voit bien là l'énorme travail.
Thank you very much, Barbara. This shows the remarkable work done by the court and the very exhaustive fiche that were produced by the Court of Justice of the European Union.